What's up, everybody? We are back in the Darrell Brooks world. Will this man go to trial again? Will he represent himself again? Will we watch another pro se trial put on by Darrell Brooks? Well, I don't think so, but we're going to find out in today's video what actually happened in that case against Erica Patterson, his ex, in the same vehicle that he drove through the Waukesha parade. All coming up on this video. We're going to break it down together and we're going to watch it for the first time. I haven't seen it yet. So you're going to watch it with me for the very first time. And we're going to figure out what exactly is going on with Darrell Brooks. So this was sent to me a few days ago, and some of you may know what the outcome is already, but I don't know exactly what happened in this hearing. So we're going to find out together because I've been watching multiple trials at the same time, haven't had a lot of time to dissect this or dig into this. So I'm interested to see what exactly happens with this case. Erica Patterson is the victim. We knew this was in addition to all the other cases. Appeals are still going on in the Waukesha parade cases where he's been sentenced to multiple life sentences. So not a lot of upside for Darrell Brooks. But what you can immediately see is that he is, in fact, in a wheelchair. And it seems like he is restrained. They're not taking any chances with him. But it's also interesting that he would be in a wheelchair still. So I don't really know what's going on with that. We'll see if they mention anything about it in this hearing. But let's jump into it.
So appear for the state. Good morning, Your Honor. Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor. Injury clothing. Good morning.
Good morning, everybody. Hi, Mr. Brooks.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges will be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin state prison system. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates.
So he's going to plead to 2 charges. 5 charges are going to get dismissed. So 2 out of 7. And they're going to ask for a substantial prison sentence, but he's also going to plead no contest. So, I mean, that's interesting. It seems like he got something out of this deal, which it seemed locked and loaded that he's going to lose this case, obviously, and the judge is going to hammer him. But maybe the state knows the judge is going to hammer him based on his prior convictions, which she can take into account when sentencing him for this. Maybe they'll matter, maybe they won't. But if by some crazy thing that we don't see coming, he wins an appeal on the Waukesha parade, this sentence would still stand now because he's going to waive his right to appeal. He's going to plead guilty. He's going to plead no contest, and he's going to be sentenced. So he's not going to have a trial for which he can appeal. He can potentially appeal his sentence if he doesn't waive that as part of this plea deal. But theoretically speaking, this could be huge in that if they do have to try him again, at least they have something where he will be in prison, although I don't think that Judge Darrell did anything to create an appellate issue in that case, no matter how hard Darrell Brooks tried. So very interesting that he got 2 things. It does seem like he got 2 things, the no contest plea, which means you don't have to admit guilt, which there are some civil implications, and just it's the better alternative than pleading guilty, obviously, and admitting that you did this straight up. But he's going to plead no contest, and he got 5 of the 7 charges dismissed. Now, does it matter? Depends on how the judge sentences him.
The amended information is not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor. And I actually did an attachment of an email string between the state and I for clarity of the record.
Okay. I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon.
So he's not maintaining his innocence. He is basically admitting all of it. He knows he's found guilty, but because of the civil implications of a guilty plea, meaning it's res judicata, she could sue him for all of his money and come and get his money as if he has any, and as if she wouldn't have to get in line from all the Waukesha parade victims, or she would be one of those victims as well, in line to collect from Darrell Brooks because of what he did with his car to her and during the parade. But for civil implications, which again, I'm a civil attorney. This is what I do. I look for ways to sue people that do horrible things like Darrell Brooks did in this case, but there's not going to be any money to go after regardless. The state decided to let him plead no contest. Maybe it was one of the ways his lawyer was like, hey, look, they're dangling a carrot for you. Why don't you take this carrot, plead no contest instead of pleading guilty, and you actually get something out of it. You come out of this with kind of a win. And maybe that's how Darrell Brooks was eventually convinced to take this plea deal.
On potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not
And that's the
objecting.
thing. Civilly, she could sue him for money, but if he pleads no contest and is guilty, well, then guess what? Erica Patterson could just apply for restitution.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. It's so that will still be a potential that will be part of.
And we've been over this before, but in case anybody is new, by the way, hit that like button if you are new, subscribe. Actually, hit the like button regardless. Subscribe if you're new. But restitution is how you collect money criminally. They don't cover everything. They cover expenses. They don't cover pain and suffering. They don't cover things in the future a lot of times as far as pain and suffering goes. They'll usually cover lost wages, medical bills, any out-of-pocket expenses. But that's why on the civil side, you can sue for pain and suffering, for loss of enjoyment of life, and all of those things. So there are more things you can sue for, more dollars you can go after civilly than what you can get in restitution. But from her case, she can still go after restitution and she can still sue him civilly. This doesn't block her from suing him civilly. It just makes it a little bit harder, not that much harder, but a little bit harder than if he would have pled guilty. She still wins in a slam dunk in a civil case if she did want to sue him, if he was collectible and there was anything she could get from him. I don't think this blocks her really that much.
So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no
two
contest.
charges. See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to two of these charges.
Brooks is kind of giggling. He seems like he's in a good mood. I don't know if he's, medicated or something, but he seems like he's in a good mood here today. He's not overly confrontational. He's letting everybody call him Darrell Brooks. He's laughing when the judge made a mistake about his guilty plea versus no contest.
That are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
So you've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the two, or sorry, I said it again, no contest plea to the two, and then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read in charges. And I can take those into consideration when I sentence you on the two that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the two that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years.
So his maximum penalties is 10 years and $25,000 fine. My guess is the state is going to ask for the max, all 10 years. I don't know if the judge will give it based on what he's going to score out based on his prior convictions. I would think there wouldn't be any problem with giving him 10 years. If I was the judge, I'd give him 10 years and a $25,000 fine.
Years is broken down into two parts: 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then,
Again, not major deals for him, but you could tack on a little bit more. So far, 10 years total, 5 in, 5 supervised, which he'll probably never get to the 5 supervised. But what we're thinking about right now is if some horrible thing happens where he wins an appeal on the Waukesha parade case, at least we know he's got at least 5 years in.
then on the
If she sentences him to that, of course.
count 1 felony intimidation of a victim that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes.
So that's times 2. So because he's pleading to 2, he's got a maximum of 5 years in for each. So 10 years in, and then 10 years supervised released, parole, probation, whatever you want to call it. 10 years in prison is his max, and 10 years supervised release after is his max. And again, I was the judge, I would give him that max based on his prior convictions, based on the connections to other things he did, based on similar acts, based on not learning his lesson, based on the fact that he's already in prison, based on the domestic relationship, based on how many victims were impacted by his decision with this car. And you can take his past acts, his past crimes, and actions into account when you're sentencing him. And the fact that he has, pleading no contest or taking responsibility at this point, I really wouldn't give him much credit for that. If it was me personally, I don't know if the judge will, but that's how I would see it personally as a judge.
Sure.
Which I am not.
You also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole.
Yes, Your Honor.
You further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty? And at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes. Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right. And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off?
And he's docile. He's agreeable. No contest. No contest, Your Honor. Yes, Your Honor, I understand. Yes, I understand. You could sentence me to the max, 5 years in, 5 years out on each count. So 10 years in, 10 years out, supervised. I understand that. Yes, Your Honor, I still want to plead no contest. Not any of the argument. He's not asking for grounds. He's not asking for subject matter jurisdiction. He's not asking for her to talk about somebody else other than Darrell Brooks, or he doesn't know who that is or not going by that name. None of the arguments we heard over and over and over again for weeks is he making here. And she explained the rights you lose as a felon, can't possess a firearm, can't vote until your rights are restored, etc. And he's okay with it.
Off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged. Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
He knows all about a trial. He knows all about his rights, and he exercised them to the fullest. And he's waiving all of that for this case. Very interesting to the people that said he's a narcissist. He's going to want to do it again. He's going to want the attention. He's bored. He has nothing else to do. He's for sure going to go to trial. Interesting that he's got a lawyer there. Seems like he listened to lawyer's advice, and he's being obedient and respectful to the judge.
You also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such
All
as
sorts of
insanity?
arguments, defenses, and challenges that we have seen him make before. He's waiving all of those in this case. What does that make you think? What does that make you think about this case? The evidence so strong. He's given up. It's over. He doesn't want to do it again. Why do you think he's acting like this in this case versus the parade case?
Self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury. injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
As to count 1 in 21 CF 5020, do you understand, that's the felony intimidation of a victim, that if we had a trial in that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from
So he's admitting all this. He's admitting all these facts, that he was the risk and the cause of potential serious bodily harm, that he was the wrongdoer, that he is the defendant pleading no contest and will be sentenced for what he is agreeing he did factually in this case. And again, all of this can be used in the civil case, that he's agreeing to all of this. He understands he was the person that caused the serious bodily harm or the risk for serious bodily harm, et cetera, et cetera.
949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as to the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
So he's admitting he did all that and the state has enough evidence to prove it. That's what a plea deal is. This is a great colloquy. And I think this judge knows exactly who this is, and she needs to make sure she's going through all of this with him meticulously, getting him to agree to all of it. And while he is agreeable at this point, we might as well get it all locked in on the record in black and white, or in color, I guess, since we're here watching it together being streamed. But I mean, this is methodically going through. This probably could have been handled quicker than this, but instead she didn't. She took her time and she's making sure she goes through every single fact and piece with him, everything he's waiving, everything that could be coming to him as far as maximum sentences go, explaining that to him in detail and getting confirmation that he understands. This is how a plea hearing is supposed to go.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions?
Woo! I mean, if that's not a gold star for this attorney, I don't know what is. He's had the opportunity to go over this with his attorney. And are you satisfied with his representation? Absolutely. From a guy that could not keep a defense attorney before and ended up acting as his own defense attorney at trial. Are we looking at a different guy here? Has he started the rehabilitation process while being in prison? I hope so. I hope that even people who seem irredeemable are redeemable and rehabilitatable. So I hope that that is what's happening here to Darrell Brooks, and he's understanding the wrongs he's done in his past and trying to work forward in prison, but still trying to work forward and be the best prisoner he can be. I do hope that for him.
Questions, or are you confused about anything we're doing here today?
No, Your Honor.
Are you pleading no contest because, again, you understand the state has adequate evidence upon which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor. And to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so we would have them, the witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that
And so there's no, competency issues. There's no issues with him understanding anything. There's no coercion. There's nothing he's doing, lying or tricks up his sleeve that his lawyer knows. This all seems legit. Seems like he's doing it knowing and voluntarily, the right way, the right reason. And this guilty plea is going to stick, according to the lawyer, which I thought that was interesting as well, getting his input, which is important. How does the lawyer see this? Does he see any issues? Does he know? Because sometimes the lawyers, we know about competency issues or the client not understanding or doing things like saying, well, I'm just going to go out there and lie. And we're like, no, you can't do that. Let's talk some more, whatever it may be. And he's saying we don't have any of those issues in this case.
alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied?
And he's saying, so I'll back that up again. She asks, any medication, alcohol, drugs affecting your client's ability in court today? Because again, maybe just the ones that are prescribed, which is okay. You're allowed to be on prescribed medication.
We were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right, the court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
Mr. Brooks, you said that you read and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true, and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there's a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense of second-degree recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state
So she accepts his plea. He is convicted as of the date of this hearing and locked and loaded. It's done. Can't take it back now without any major problems happening in the background that would be completely shocking.
moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this. This was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
All right. And is
I'm not moving for remand. I normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscoville, I'm not asking for remand.
right? I agree with that.
Correct.
Generally, I would remand someone given the seriousness of the charges that you just entered into and what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that.
So he's going to go back to where he's serving for the Waukesha parade, and not going to be held in remand, which he would if he was pleading to such serious crimes and the state was asking for a serious prison sentence, which is going to be the max, is my guess, what they're going to ask for. But we'll see. Sentencing is getting set off. There's all sorts of issues we've got to deal with at sentencing, restitution, statements made by counsel, by Brooks, by the victim, by family members. So we'll see if all that happens at sentencing. No pre-sentence investigation or report in this case. Again, I think it's going to be pretty simple, but maybe I could be oversimplifying it.
Specific reason, I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome.
I mean, he's laughing at the fact that the judge is like, guys like you that agree and admit that they've committed such serious penalties, we want to make sure they're held in jail or prison and not going to flee or do anything else. So as long as we know you're being held, that's all we care about. And he's like, yeah, thanks, Your Honor. I'm definitely being held over there in prison for what I did at the parade. I mean, that's what he's laughing about and joking about. And the judge is like, okay, it's weird, but that's what we're dealing with here.
So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome. All right, so I have some warnings for you. You may not have any firearms, as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in place at least until after sentencing. All right, we will select a sentencing date, and I will see you then.
Thank you, Your Honor.
You're welcome.
Parties available August 9th at 9 o'clock.
No, that week I can do any of Monday, Tuesday, or the Wednesday, not the Thursday or Friday.
That week is not good for this court.
Okay, then the following week is a good week for me, except for Monday.
Okay.
Generally,
August 16th, 9 o'clock.
that'll work.
Works for the state.
Yes.
Next court date will be August 16th at 9 o'clock for sentencing.
Friday, August 16th. Where's your promise to leave it? I get you.
I want to go.
Friday, August 16th.
So
court
August
date will be-
15th is sentencing in this case. And a ton of you guys sent me this video. So if you want to talk about sentencing when that comes out, send it to me and we'll see what's going on. But if we've got time, we will do a breakdown and reaction just like we did here. Darrell Brooks is back and he's going back to prison. He's pleading guilty going to prison for more time. He's going to stay where he's at for Waukesha, but to get another 10 years with 10 years of supervised release as a little insurance is never a bad thing for somebody who's done what Darrell Brooks has been convicted of doing and now admittedly done to his ex, Erica Patterson. So she gets her justice as the victim in her case as well, which is the point of the justice system. And that's why we continue to go forward on cases like this, even after he's serving multiple life sentences. If you guys have questions, throw them in the comments, hit that like button. If you came back around to talk Darrell Brooks with me today, tonight, whenever you're watching this, I appreciate you guys for everything you do, all the content and comments and questions you bring to the channel. It adds more than you know. But for now, that's all I got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.